I'm going to start this off with a mea culpa. Chauncey Hollingberry did hire a registered process server to serve Maricopa Unified School District, so I was wrong on that. In order to do this analysis, I did look quickly at an Arizona defamation lawyer's website. This does all appear to be just standard MBE stuff. I'm not going to use this in my analysis because it appears to be just standard MBE stuff. So I'm probably going to be wrong on small details, but take that for what you will. What he is doing in the part of his little video I'm looking at, this notice of claim, is 12-821.01. The claim shall contain facts sufficient to permit the public entity, public school, or public employee to understand the basis on which liability is claimed. The claim shall also contain a specific amount for which the claim can be settled and the facts supporting the amount. He's suing, in the heading, he's suing, let's see if I could find it. He's suing Maricopa Unified School District. He's not actually listing Jaime Morano as a defendant. So that might play into this analysis. I also don't know what an action for negligence with reckless disregard is. Because negligence, like if you sue someone for negligence, you have to show that they had a duty of care. You have to like say they had a duty to protect you or a duty to whatever. They had a duty to do something, a duty to warn, a duty to make safe, something like that. They had to have some sort of duty, and they had to fail to fulfill that duty. He said duty. Reckless disregard. So reckless is like a step above negligence. I couldn't find anything. I just did a quick search for Arizona negligence with reckless disregard. I have no idea what that is. So that could be a problem. If you sue someone for negligence, you don't have to prove reckless disregard. And last I checked, reckless disregard, if you prove negligence, that's all you needed to do is prove negligence. Now, there is some element of reckless disregard if you are dealing with the malice, the actual malice standard of slander. That's the New York Times V. Sullivan issue. If you're dealing with a public figure, then you have to prove malice, actual malice. And that would be either knowing that what you're saying is false or having a reckless disregard to the truth or falsity of the statement that you're making. Like just like if you did a modicum of research, like if you just took the time to Google it, you would know, you'd be put on notice that what you're saying is wrong. Or if someone says, hey, by the way, what you're saying, what you're about to publish is wrong, you might want to double check it, then that might work. But I honestly don't know what he's going for with negligence with reckless disregard. And I'm a lawyer, so I don't know. I could be wrong on this because I'm not, like I said, I'm not an Arizona lawyer. And I just did a quick Google search, so do with that what you will. Always talk to a local attorney if you're seeking qualified legal advice. So this is his notice of claim. We're looking for facts. Chauncey Hollingberry, a private figure, that is a legal conclusion. That's not a fact. He would have to show that he's a private figure, not just claim it, if he's trying to say that it doesn't apply to him. Now, he doesn't want to be a public figure because then he'd have to prove the actual malice standard, and he may be. A public figure is like typically like a household name, but there's also limited public figures, and he may qualify for that because he had a lot of interaction with the school. This is the claims that Jaime Marano made were in relation to the school. He inserted himself in it. He may be treated as a public figure for it. So it is definitely not a settled question as to whether or not he is a private figure. He has 10,000 subscribers. So would that make him a public figure? Maybe, maybe not. But inserting himself into the public affairs of the Maricopa Unified School District may make him, at a minimum, a public figure, a limited public figure for these purposes. So he provides a notice of claim pursuant to ARS 12-821.01, subsection A. The good faith cause of action sought are per se slander per se. Going by the MBE, I don't know if Arizona has changed any of these. Going by the MBE, there's four types of slander per se. There is where you say that someone has committed a crime that involves moral turpitude or is otherwise an infamous crime. Moral turpitude means like it's perjury or embezzlement, something that involves in being dishonest or having a bad character. And then infamous crimes would be something that involves imprisonment or the death penalty. Falsely accusing them of that. The second one is claiming that they have a sexually transmitted disease. The third one would be claiming that they are unqualified for their job, like saying that a doctor has an alcohol problem and he goes into surgery drunk. That could be slander per se if it's not true. And the fourth one only applies to women. If you accuse a woman of being a whore, then that is slander per se. Slander is typically spoken actions. So I don't know. Different states define the difference between slander and libel slightly differently. Like, is a YouTube video slander or libel? It depends. Some states have it. If any permanent kind of recording of it, then it's libel. A transitory recording is slander. But the state would know which one it was. If he's saying it's slander, I'm willing to roll with that. I don't know exactly. He doesn't allege what exactly was said on social media. Like, was it a Snapchat where it went away like that? Or was it a permanent post? Well, he says it's ongoing. I have a feeling that he should be claiming libel, but again, it just involves Arizona case law. And negligence with reckless disregard, I have no idea. He doesn't actually allege any facts that would go towards negligence with reckless disregard, so I'm not entirely certain. The elements prescribed are the defendant made and said, so the defendant is Maricopa Unified School District. So the defendant made and said defamatory statements regarding plaintiff. The statements were false and they were communicated to a third person. Those are the elements that he has to actually provide facts for. That the plaintiff said something, that thing was untrue, and that untrue statement caused damage. But he has to plead facts that support that. The Maricopa Unified School District labeled plaintiff as unhinged. How did they label the plaintiff as unhinged? And a threat to the school, and a threat to a school teacher named Jaime Marano and her school children. How did they do it? You have to actually allege the facts. Who in the Maricopa Unified School District said it? When did they say it? Where did they say it? Who did they say it to? What specifically did they say? Did they just say that Chauncey Hollingberry is unhinged and a threat to Jaime Marano? Your guess is as good as mine. We don't know. These statements were communicated by Jaime Marano on social media. Wait. So was it the Maricopa Unified School District who said it, or was it Jaime Marano, or was it Jaime Marano in an official capacity speaking for the Maricopa Unified School District? Can she speak for the Maricopa Unified School District? Did she do it in her role as a employee? Did she do it on her own time? Did she do it on her own computer? We don't know, because he's terrible at making a pleading. Okay, so these statements were communicated by Jaime Morano on social media with a minimum viewing of approximately 500 with continual and present viewership. Okay. Jaime Morano indicates defendants were aware of evidence involved which disputes defendants' allegations. Okay, so if he is a public figure, that may put them on notice that the statements are false. That would be the reckless disregard, would be the actual malice standard, etc. My wife just remotely turned on the sous vide, and she had to tell me about it. So that's good. We're having pork chops tonight. You jealous? Where were we? Okay. So if he's a private figure, I don't think it changes anything. But I'm again going off of the MBE kind of version, not the necessarily what Arizona would hold. So then he continues, defendant has a political motive for allegations due to plaintiff's government accountability stance. So is it the defendant Jaime Morano? Because she's not a defendant, or he, excuse me, I don't know. I shouldn't assume gender. I believe Chauncey said it was a her, said that he or she was a her. So I apologize if I've misgendered Jaime Morano. So was it Jaime, or was it the Maricopa Unified School District? Who has a political motive? What is the political motive? And how can you show that it was due to the plaintiff's government accountability stance? Is it from the political stance, or is it from your actions of, I don't know, maybe going into the public school wearing a mask and being a general jerk? Because that could also make people not like you and make people think you're unhinged and make people think that you may be a danger to school children. I'm just guessing. That, and maybe a legacy of videos showing you stalking people. That could also, I'm just spitballing here. So, we're not in court. This isn't evidence. I'm just throwing it out there. Plaintiff is demanding speculative damages. So if you prove slander per se, you don't have to prove actual damages. But he hasn't alleged any of the elements of, at least by the MBE standard, of slander per se. So if he doesn't prove them, then he has to show actual damage, and he'd have to have facts. Like he'd have to say, because of the statements made by defendant, my employer heard of them and fired me, and so I lost X amount of money, because that's how much I would make over the period of time, etc. Because of the statements of the plaintiff, I was diagnosed with PTSD, and now I spend Y amount of money per week seeing a therapist. Because of the statements that were made by the defendant, a potential client or a potential business contract heard of those statements and ceased doing business with me, or chose to not go into business with me, costing me this amount from the contract. Conversely, the defendants can show that because plaintiff monetized videos about defendant and about defendant's actions and made money off of them, the defendants can say that you did not suffer actual damages. So it's going to be very important for Mr. Chauncey to show per se slander. But then he wants to say mental and emotional anguish and loss of reputation. That's not, there's no facts there. He's just saying that he has mental and emotional anguish and he has loss of reputation. But the videos of him giggling like a schoolgirl, where he knows that he's getting to these Maricopa employees, may undercut his claim of mental and emotional anguish and loss of reputation. So this was terribly pleaded. He did not plead facts. He pled just a bunch of legal conclusions. The defenses, of course, open to the defendant are that, one, he is a public or limited public figure, and there is nothing to suggest, online or any other way, that he is not unhinged and or a danger to her school children. Again, if I misgender you, Jaime, I apologize. But there's nothing to show that. Just the video of Chauncey busting into the school wearing, which was reported in the news media. So one would have a very easy time saying that this is a limited at worst, public figure at best. He's been reported on in the news, for crying out loud. I don't know how. Yeah, there's news stories on him. He is anyway. So that is my legal analysis and my legal opinion, but it is not legal advice. This does not appear to be a very well written. I don't know if slander works. I don't know what he means by negligence with reckless disregard. I don't believe that he is a private figure, at least for the purpose of this. I don't believe he showed that the plaintiffs were, well, he doesn't have to, but I think the defendants have a good chance of showing that he is unhinged and or a threat to the school children and the teacher. I think also that the defendants have a good position to show that that is an opinion. They're not saying he was diagnosed. That unhinged isn't a diagnosis. If I say you're ugly and your mom dresses you funny, that is an opinion. You don't have to say it's my opinion that. But if I say it's my opinion that you have a sexually transmitted disease, that is actually a fact you're trying to disguise as an opinion. So I would posit that this will be treated as an opinion. I think the chance of success on the pleading is terrible, and on the merits is also terrible. And I am just enjoying this every step of the way. Once again, I am not licensed to practice law in Arizona, and I did just the barest modicum of research on this. But this will be interesting and fun to watch. Thank you for watching, and have a great day.